All right. Well, so today I have a special guest joining me. So Kelsey Humphries from Underwood Gilhome. Kelsey is a wills and estates lawyer with Underwood Gilhome. And today we're going to be talking about the 5 myths of estate planning. And so to kick that off, the very first thing that I want to talk about with Kelsey is the myth that I have a will, so I'm good. I have everything covered. So Kelsey, what are your thoughts on that? I'm sure you hear that a lot as a wills and estates lawyer, and I'm just curious to understand a bit about your thoughts.
Yeah, definitely hear that a lot. And I think that's one of kind of the first pieces that I address even when a client reaches out is they say, "Well, I want to update my will." That's great. But again, we really want to look at the bigger picture. And so when we are talking about estate documents, typically there are three big ones: will, power of attorney, and personal directive. And so the will obviously covers things after you pass away. The power of attorney and your personal directive are your incapacity documents. So these are you're still alive, but you lost the ability to manage your affairs and make decisions. And so this really just gives an opportunity for someone else to be able to automatically step in. And there are even times where I say, in some respects, a power of attorney is more important than the will because you're still alive and you still have a vested interest in how your affairs are being managed, your bills are still being paid. And so again, when we talk about kind of the estate planning package, I would say those three documents, first and foremost, should be treated equally. So a will is great. There's no taking away from that. But again, just broadening it to make sure that those incapacity documents are also included.
Yeah, that's good advice. And so oftentimes when we talk with clients about, getting their estate documents in place, one of the things that we talk about is executors, right? And the attorney or the agents. And we often hear where parents say, well, I want to name all my children as executors. And that can cause some problems. And so do you hear that often as well?
That is. And I think that really dates back to when the executor role was still seen as to be an honor but to be bestowed upon family members. And so again, I always like to deal with that misconception as well, just because for anyone that's done it, it's a lot of work, it's a lot of responsibility, it's more and more liability as kind of things get on and things are more complex. And so that's piece number one, I think, when we're dealing with an executor appointment. But then moving away from that and looking at that co-executor, it is important to note that when you have a co-executor appointment, it has to be joint. And we are still in kind of a stage where almost every estate document requires the original signatures of both executors. And so if everyone's working together, they live in the same place, they're both contributing the same amount of time and effort to the role, then again, that doesn't happen as often as most people probably envision when they think about that. So if you do envision one of your children taking on the majority of the work, or especially if they're not both conveniently located or if they don't get along the best already, I would say just really try and avoid that co-executor appointment because often adding them creates a lot more work just going back and forth to get kind of signatures and those pieces on the estate administration when they're working together.
Yeah. Okay. Well, that's good to know. So when it comes to appointing an executor, and the parent is trying to choose between one or two of their children, what are some ideas and some recommendations? How would they know, who's going to be the right fit for that role? Because that's a pretty big role, and it's important to make sure you have the right fit.
It is. And so just going back to, I would say if they want to keep, I mean, yeah, I've had this conversation many times and they say, well, I still want to go ahead with naming both of them. If we are going that way, then I would recommend just adding a further provision just saying in the event one of them is unable or unwilling to act, then the other one can act alone. And that
Hmm.
just allows them the opportunity just to see where they are at their lives, where they're located at the time of passing, and then really be able to determine amongst them who's able to take that on. Because again, yes, you can look at children and say you have the financial acumen or the you're responsible enough to take that on, and usually that's not the issue. But again, if they have minor children, if they're building their career, if they're traveling a lot, or they're snowbirding in another country, I mean, those are all factors to be considered. It's really not just can they do it; it's do they have the time and the desire to do it as well. So I would say think of all of that. If there's one child or one person that automatically stands out, then I always recommend drafting the will so that if something were to happen tomorrow, kind of who is the best person to have in place at that time. Just keeping in mind that once you have the bones of those estate documents, it's very easy to kind of amend and change down the road as well.
Yeah. Okay. So let's say we live in Alberta. Let's say that a parent thinks that their child in Ontario is going to be the best fit. Is there any issues with naming a child in Ontario as an executor of an Alberta will?
There's some There's some minor issues. So the biggest one is that right now in Alberta, we have an online filing system when you retain a lawyer to do an application for probate. And what that does is it's simplified and really expedited the estate administration process. I've had applications for probate recently that have been turned around in 9 days. And so that is only available when the executor is resident of Alberta. So that's one small consideration. Another one is just again factoring in there is still some on the ground work to be done. So just factoring in, does that person have the time to travel? And really, when we're talking then about compensation, it's just recommend building in that express provision to say that those things like travel costs and expenses and accommodation expenses can be covered for, again, anything that needs to be done on the ground.
Hmm.
The final piece is just the bonding provision. And so, again, this isn't the end of the world, but it can present issues if there are other issues for the estate. And so, what bonding is, it's essentially the court saying if you live out of province, the default requirement is that you have to post money or security with the court to be able to act as executor. So, most often we will include a bonding provision in the will, just saying it's not your intention that a bond would have to be provided. But it
Hmm.
does come down also to beneficiary agreement. So those I would say are the three complexities. So often I say, I mean, the distance shouldn't be a limiting factor, but there are these pieces to consider, and certainly give some thought when you are weighing who's the best fit for the role.
Okay, that's good advice. And so the next myth that I want to talk about is I need to avoid probate, right? There's a lot of talk about probate, and I know there's different rules in different provinces. I know that probate in Ontario, for example, and BC is a little different than what it is in Alberta. Can you expand on that a little bit and maybe address some of those concerns that people have around probate?
There is. So I think a lot of the misconception comes from the fact that a lot of our media coverage tends to come from Ontario. And so
Hmm.
Ontario has the highest probate fees of every province, where you are essentially taxed 1.5% of the value of any of the assets that fall into the estate. And that's something that has to be paid when the application for the grant of probate is made. So 1.5% on assets can be significant. And so there's a lot of time and money spent to avoid probate. This is similar in BC with 1.4%. In Alberta right now, we have $525 is our kind of max probate fee. And so when we look at that, I always say it is a low hanging fruit. I think every change of government, we always look at, well, are we going to have a tiered probate fee like almost every other province in Canada? But again, right now, when we're dealing with the current state of affairs in Alberta, it's $525. Another piece too, which I kind of alluded to before, is just the timing with probate. And so there were times during COVID where it was taking 8, 10, 11 months to get an application for
Wow.
probate through. And essentially, things were frozen and you couldn't access assets during that time. Right now, like I said, if we have that online filing system, we're at about 3 weeks is the typical turnaround time for the court to deal with that application for the grant of probate. So and
Yeah.
even if we aren't able to use the online filing platform, we're still at about 8 to 10 weeks. And so it really is something where it's definitely a consideration. But in Alberta, $525, very quick turnaround. So the steps that people often take to avoid probate when it's deemed to be kind of a significant consideration, things like beneficiary designations and joint tenancy on accounts and property, that's simply not something that's recommended in Alberta just because probate is such a minimal concern at this time.
Yeah. Yeah. Okay. Uh, Pretty big difference. $525 compared to 1.5% of your overall estate. So definitely a big difference there. So the next myth that I want to talk about, myth number 4 is, my family all get along, my kids get along. I don't know that I need a will, or maybe I can just get away with a very simplistic, basic will. I'm sure you hear that a lot as a wills and estates lawyer. And so how do you address that? How do you communicate that maybe that's not the best action plan for clients?
Yeah. So again, there are many people that have a simple will of just saying everything goes to my spouse. And when my spouse passes away, everything goes to my kids. And a lot of the times we're not trying to add complexity, but what we do is we take our experience and we take our knowledge and understanding of seeing everything that can go wrong and try to address that at the outset. So I think even if you want to stick with that ultimate distribution schedule, there are some other pieces to be considered that are often overlooked. And those things are things like personal effects. So again, everything can go to a spouse or to children, but do you have any specific items that you want to carve out or that you want to direct to certain beneficiaries? Unfortunately, with a lot of the times when we see the family blowups and the family disagreements, it's not even so much the value of the estate. It's about one piece of jewelry or one family
Yeah.
heirloom that hasn't had any thought being given to it. And what that does is if there's multiple people that want it, it can just completely tear families apart. So even if you choose not to formally incorporate anything, it can be good to just think about it, have those discussions, and then again, ideally address it in a will if there are some potential for disagreements there. And then alongside that too, I would say the second piece that is often overlooked when we deal with those simple wills are gifts, loans, and advances that people make during lifetime. Again, if you do a 50-50 split between your two kids, that's great. What if you've advanced one a
Mhm.
significant sum for the purchase of a home, a wedding, things like that, where if it's not equalized, that can again lead to family disharmony and potential for disagreement. So often we address those in one of two ways of either factoring it in and kind of taking those gifts, loans, and advances into account, or using the will to expressly exclude it so that there's no potential for disagreement when a will is silent when it comes to those funds that may have been advanced during someone's lifetime.
Yeah, that's good. That's a good advice. We come across it all the time with the families that we work with, where they want to advance child money for schooling or a home or a car purchase, and the kids are at different ages, so those advancements come at different times. So I think addressing that is really important. I also find that going through the process of working with a client to help them draft a will is a really good exercise because it just promotes the discussion of what they want to have happen with their estate, and it gets everyone on the same page, and it's open dialogue, and I think there's huge value in having that open dialogue for sure. So the next myth, number 5, and I'm sure you hear this all the time, or maybe you don't, but I've hear a lot of individuals talk about it, like, do I need a lawyer for a will? Can't I just go online to one of these platforms or use a will kit and draft the will on my own, or even just write it out on my own? And I am absolutely not a proponent of any of those. I do think going and meeting with a wills and estates lawyer such as yourself is the best way. But how do you address those concerns? And what are your thoughts about individuals that think, hey, I can go out and do it on my own and get a will kit?
Yeah, so I'm going to give my unbiased opinion here as best I can,
All right.
Jason. I'd like to address kind of those three different scenarios individually. The
Mhm.
first is just a handwritten or a holograph will. So, right now, those are legal in Alberta, they are valid. The problem is that that's not the case in every province. And so, I had a client recently that had a holograph will and had property in BC. And so, the will was fine in Alberta, but again, BC does not recognized holograph wills. So we ran into some significant issues there. I always say too, the legislation may change in the future, and so if they did remove that ability to use a holograph or a handwritten will, most people likely wouldn't know that that's been changed, and so that's kind of the first concern that I would highlight there.
Mhm.
Then moving to the online platforms, these have become incredibly popular. And normally they say having something in place is better than nothing. There are some platforms that will take kind of basic instructions. And if there's any kind of complexity, they kick you out and essentially just say, this isn't something that we can accommodate. Please retain a lawyer. So I do admire that piece. The difficulty with the online platform is that you're given kind of the instructions, but then you're left to do it yourself and there's no liability there. So, again, another situation we're dealing with right now, a gentleman won through an online platform, but at the end of the day, he didn't have it witnessed properly. He didn't
Right.
have the two witnesses being signing all together. And so that's now an invalid will, and it's not kind of worth the paper that it was printed on, so to speak. And so that is something that, again, when it comes to the liability and it comes to just that confidence of knowing that everything is in place and everything's done properly, I think that again speaks to just the comfortability and the advice and the knowledge that an estate lawyer can bring to your situation. And that's unfortunately, if it's not done properly, it's not something that you know during your lifetime. It's often something that you find out after the fact. And so that I would say would be the biggest concern is you're kind of left to your own devices to not only craft the will and do the estate planning yourself, but then also execute it properly so that you know that it's a legally kind of valid will.
Yeah.
And I just think in the grand scheme of things, I mean, most people have amassed a significant amount of wealth during their lifetime. And so when you look at it, yes, it can be a significant upfront cost, but I also look at some wills where, again, it's a simple will. Someone leaves everything to their spouse and then to their kids. And when you look at that, I've reviewed wills that are 25 years old and they were still fine and there were no changes to be made. So I really would say it can be a significant upfront cost, but you know it's done properly, you know it's valid, and then at the end of the day, it may, if you kind of cost average it over the number of years that it's valid for, I think it's worth your money to have it done properly.
Yeah, without question. I find that clients sometimes they push back a little bit and, oh, do I am I ready to do it? I have to think all these things through. But the reality of it is that once they go through the process and they finalize those documents, there's tremendous peace of mind that comes with that. And they've opened up a whole lot of discussion with their family members that they wouldn't have had before. So it's a great exercise. As a family office, we love taking clients through that exercise. Every one of our clients ends up with well drafted estate documents through working with great individuals like yourself. So I really want to thank you for taking the time to meet with us today and share some of your insights. I think it's super valuable. If anybody is looking to ever reach out to Kelsey to get estate documents drafted or just wonder how she can help them, I encourage you to send her an email. So Kelsey's email is KELSEY.Humphries, HUMPHRIES, at Wills, WILLS, estates, ESTATES.ca. And I run a company called 360 Wealth and Estate Solutions. Our wheelhouse is working with business owners who are within 5 to 10 years of selling their business or they've recently sold. So if you think we can help you out, check us out at 360wealth.ca. We'd be happy to chat with you and see if we can help shed some light on your situation. So thank you for joining us. Take care. Thanks, Kelsey.
Thanks, Jason, for having me.